They were already booked up.
All right, good morning, everyone. Welcome to our meeting. And everyone should be thankful we were not here last week when it was 110 in LA, so it's only going to be in the 90s today, so it's all good. Thank you, Natalie. Yeah, everyone turn your phones off. So we do not have microphones on the desks here, but the microphone on the camera is super sensitive, so if there is side talk, it probably will be picked up and broadcast for all to hear later. Good timing, Doc. Welcome. We are going to have a guest who is appearing at approximately 12:20 by phone, Richard Schaffler from the Office of Research and Institutional Accountability. And Amy and Natalie will be describing a little bit more about what he will be talking about. Our next meeting, and this may or may not be on some of your calendars, so be sure to make a note of it, and there will be announcements from Adrian as usual. But the next meeting, which will still be part of the current term, so for those of you who are rotating off, this is still your term, will be September 28th in San Francisco. A tentative agenda had listed the meeting previously as Los Angeles, so it will be in San Francisco, just to make sure you're in the right city for the meeting on September 28th. We'll take lunch around 12:30. It depends how long our session with Richard is, but as soon as that is over, we will have our lunch break. And with that, let me ask Adrian to take roll.
Glenn Plattner.
Here.
Michael Berg.
Here.
Jeffrey Hayden.
Here.
Lou Esmond.
Here.
Miles Friedman.
Here.
Robert Hershenson.
Here.
Jeremy Klein.
Here.
Mark Lester. Cynthia Levin.
Here.
John Munsell.
Here.
Donald Shepard.
Here.
Aurelio Torre.
Here.
L. Robert Burmese.
Here.
All right. Robert, we're grooming you to be an officer, which is why we have you sitting over here.
Oh, wonderful. Thank you.
Thank you for joining us on this side. I'm not sure if there's anyone on the phone, but let me make a call for public comment. There are no public members in the room. And not hearing any, I'll move on to my favorite part of the meeting, which are the staff reports. And Natalie, I think you're starting on that.
Sure. So as for legal specialization, most of my report is actually subsumed within the agenda. So I will defer, and then at the conclusion of the open session, if there are any programmatic questions, I would be happy to take them.
All right. That's why it's my favorite part. Okay, and Amy, you're going to talk about the State Bar
Updates, yes.
updates. Yes, thank you.
All right, so I'm going to start by talking about a project that's underway in the Office of Admissions, and that is a project that was directed by the Board of Trustees at their January meeting. The board asked us to look at our special admissions licensing schemes. So this is multi-jurisdictional practice, specifically registered in-house counsel, registered legal services attorneys, with an eye for opening it and broadening more access to justice efforts in those arenas. So we have a group combined of the Office of General Counsel, staff from admissions, and legal services have been working together to look at those positions to determine what methods we can revisit and modify any part of those rules to allow greater access and greater opportunity for either pro bono work or access in general. And so we are in the process of formulating a proposal that is going to go to the CBE, to the Access Group, as well as to the board in September. And again, this is aligns with one of the Board of Trustees' strategic goals for the year, and that is for the next 5 years, actually. This is a goal that aligns on access to justice and increasing access to justice. So as soon as we get some language, I can have Natalie share that with you if you guys are interested. Another item, I'm sorry, I also didn't talk about this, but we were also directed to look at, to propose a rule that would create a special admissions process for military spouses. This has come up in the past. Other states have a rule or a special admissions process for military spouses. In California, we don't have reciprocity, so that's been a challenge for us, given that we are not a UBE, that is a Uniform Bar Examination state. So that what we're doing is we are proposing a rule of court that aligns with the registered in-house counsel and registered legal services attorney, so that it would have the similar oversight to allow spouses of military personnel to practice under supervision of a California attorney in California. And that, again, is being bundled with the MJP process so that we can have the CBE and access, as well as the board review it. And in September, once the board approves with whatever modifications they might provide, it will go out for public comment, 45-day public comment period in September. Are there any questions?
This might be a very overly technical question, but would those count as years of practice for someone, like theoretically, like if they were going to become a specialist or something like that? For instance, if they were going to apply to do that.
That's a good question, and I think it's something that we need to explore, and I can add it to our lists of considerations, because for the military spouse attorney, that's looking like it's you have the same rights as an attorney despite the supervision. So so then we have to factor in. So thank you for raising that. I will look into that.
Any other questions? Well, we're definitely interested in seeing it, Amy, so anything you can share with us, definitely
Absolutely.
share. Thank you. Happy to look at it and comment.
Okay.
Anything else?
Yes, I have
Yeah,
a few
go ahead.
other items. So I just want to give everybody a heads up on the California bar exam is coming, just so that you're aware. We have approximately 9,221 applicants that are coming. It represents approximately 7% decrease compared to last year, when we had close to 10,000 people that registered for the bar exam. So we are going to be at 16 sites starting on July 23rd. The exam, again, it's a 2-day bar exam that starts July 24th. And we are still in the process of recruiting proctors. We need approximately 1,500 proctors. We are making a lot of progress, but we're just tying up loose ends, so just an idea of where the Office of Admissions is right now.
Who can be a proctor? Anyone who volunteers?
Yes, you need to be over the age of 18, and we conduct the training, so you just need to be over the age of 18 and be able to work in California.
And does the bar know why there's a 7% decrease? Was that expected, or is that a trend we're seeing, or is it maybe a one-time thing?
Well, we typically have more people that apply for the July bar exam versus the February. We think that the uptick, there's potential that the uptick that happened in July of 2017 can be attributed to the fact that it was our first 2-day exam cycle.
Yeah.
And so we actually have more than we anticipated.
Okay, so people may have delayed taking the February 2017 exam in order to get a 2-day exam. They just
also because of the academic scheduling, we usually can get more students. So it could be a combination of that. So that we typically have more people graduating around May, June, so July is they're prepared for the exam, as well as perhaps people who waited to see how the first round of the 2-day cycle went.
Question, Ken?
Yeah.
What is that new program, that preparation?
Yes, so you're talking about the productive mindset intervention. Right. Yes, good question. So the productive mindset intervention is happening in conjunction with this bar exam. So it's a one-time occurrence, meaning that we don't anticipate that this will be implemented in February or for the February bar exam, let's say. And so what it is students or applicants who are applying for the bar exam had the option to participate in this positive, a productive mindset intervention, where once they enrolled, they were going to get information on through a storytelling process. A positive mindset was going to be created. The registration for that ended on May 14th. It closed. And then we had the results of the February bar exam released in May, on May 18th, so 4 days after we closed the registration. However, we opened it up and reached out to those who had registered between the date closed and the day that we reopened it, so that everybody was granted that opportunity. Our registration process ended at the beginning of July, so that we are everybody had that opportunity to participate. Where we ended up is I think we had approximately 1,200 people who applied in the first round, and perhaps another I believe it's something like 300 that came in post-process. And so those initiatives have started. They started on actually May 21st, which is why the original cutoff was on the 14th. But we were still able to accommodate those that wanted to register after. And now we await the results of that initiative.
That's great. Thank you.
Sure.
You have more?
Yes, I do.
All right, keep going.
So the other item, and I'm not sure how much you talked about this, it's related to the bar exam studies. As you recall, in 2017, the Supreme Court directed the State Bar to take on some bar exam studies that are looking at a few things. The first part, there was 4 studies altogether that were requested. One was looking at the characteristics of people who took the bar exam in 2008 compared to cohort to the entire population in 2016, looking at whether there were characteristic differences between the applicants. And that report was published by Dr. Roger Bullis, and it was published, it's on our website. And there were 2 other studies. There was the standard setting study that evaluated whether the existing pass score reflects the minimum competence of entry-level attorneys. And that also had the CUT score connected to it. The other study is the content validation study, and that looked at whether the topics that are covered on the bar exam were appropriate in terms of their breadth and of their depth, and whether they align with the knowledge and skills and abilities that are required for entry-level attorneys. That job analysis utilized, that study, both of those, relied on a job analysis that was conducted by the National Conference of Bar Examiners in 2012. So one of the suggestions and recommendations that was made after those 2 studies were released was to have a California-based job analysis, and that is what we're in the process of conducting. And so just so you know what a job analysis is, it's a body of research that's examining the expected level, the expected skills of an entry-level attorney. And so the goals of that study are to look at to gather information from entry-level attorneys around the state to find out what kind of assignments they're receiving, and also to know what knowledge and skills are required for that assignment. And through capturing this information, we're going to be able to look at, first, to ensure that the exam content, and that, again, that's the breadth, depth, and complexity, is related to the knowledge and skills required for entry-level positions. It's also going to provide a documented link between the exam content and current legal practice, which is why we wanted it to be a California-based study. It's also going to assess the adequacy of the exam format in the testing requisites and knowledge for the knowledge and skills required for attorneys in California. And it's going to also inform the development of the minimum competence definition for the standard setting study for future study as well, or for future requests on this information. And so where we're at right now is we submitted a request for information And this is a proposal to look out to see if we have entities that are working in this arena, whether it's in the job analysis in general, because there's people that do a lot of fields conduct job analysis studies, medical field, other types of licensing entities, and also looking at the methodology. And so through that information that we gathered, we also submitted a proposal to Access Lex, and they will be funding the study. So we have a funding source, and we're in the process of selecting the vendors, because we also had a request for a proposal. We have, I think, approximately, I can't remember how many vendors right now, but we are doing evaluations, and once that is gathered, we're also formulating a working group, and that is going to constitute our next initiative. So we have a job analysis that's coming, a California-based one, shortly. Yes.
Questions on that?
Just curious, who does that study, or what do they draw on to determine what the attorney is doing? Are they contacting lawyers, law schools? How do you?
Yes, great question. Because I missed this one part that we are doing in California. We're attempting to use a methodology that will help with the data gathering process. So we will be contacting all entry-level attorneys in every single practice setting, and we're creating an application or some type of electronic system for gathering this information. And so what people are going to get is, it's this methodology called random moment. They will get a ping, some sort of ping, that will alert them that you need to answer this question. It's going to be a few questions that they can tell us, like, what is it that you're working on right now? What did you need to know in order to conduct this? And through the collection of multiple observations, we'll be able to define that. The way job analysis have been conducted in other settings is you get a big list of a questionnaire that you have to answer. So we're hoping by this a modern method of data collection that will get a higher response rate and also a better, higher quality data.
Will it just go to new attorneys, or will it go like first through fourth years? Or?
It's, I think, new attorneys are targeted.
Okay.
Mm-hmm.
And then, do they still do the performance test, or
In the bar exam?
in the bar exam?
Yes.
So this will presumably lead to revising that or refining that?
That's what the content validation study did, is it looked at the questions and the performance test in order to evaluate whether they reflect the breadth of knowledge that are required. And so, yes, so information gathered by through the job analysis will look at the linkage between that bar exam and what is required.
Or it could lead, if I understand it right, to entirely changing the topics on the bar exam.
Possibly.
Like, adding one or subtracting one, probably civil procedure will always be there, but it could change it slightly.
Yes.
Or say it's perfect.
Exactly. So that would be the content validation study, and the other is also looking at the standard setting study. So is a standard too high or too low as it stands now compared to what's required of entry-level attorneys? So it's going to address both of those aspects.
It's very interesting. And you have more to report, or we have plenty of time, so keep going.
So I don't know if you were going to talk about aims.
Oh, good.
We will talk about it. We do have an item a little bit later in the meeting, but I have received some questions about fingerprinting.
Oh, yes.
At the beginning of the meeting.
Sure. Okay. So perhaps I'll just start with the background. So in 2017, on July 1st, the State Bar entered a contract agreement with the Department of Justice to be able to enroll bar applicants at the time, and now we're doing this for licensees. In the subsequent arrest notification, we had not entered into the contract prior to that, and for that reason, attorneys are being requested to re-fingerprint so that they are enrolled in the subsequent arrest notification program. And so I think everybody has through December 2019 to register. We have a process to re-fingerprint. We have a process for anybody who's out of state or out of country to enroll through the fingerprint cards. That is being run out of the Office of Admissions, and Arthur is the centralizing both the information sharing in terms of the time frames with penalties connected to meeting each of those deadlines, as well as answering any questions that might come up related to the fingerprint initiative. So it got launched what month are we in? I think possibly in May.
Yeah.
And
Yeah, our firm did it. Our firm brought in, for all the attorneys, a fingerprint company, whoever does it. So it was very easy.
Okay.
And then, yeah, it's easy to register on the State Bar website.
Yeah.
Amy, I know they already have done it and it's in process and it's been a long time, but I could have sworn we had to get fingerprinted when we took the bar exam.
Yeah.
Yes. There have been, I think traditionally, there are two instances where applicants to become attorneys or to become licensees were fingerprinted. First, it happened what was part of your moral character application, and secondly, it happened at the bar exam. And both of those fingerprints were used for different reasons. One is to verify your identity. That's why fingerprints are required at the bar exam. And then secondly, it was to conduct a background check. And so this initiative is for new applicants, it's for the background check and also to enroll in the subsequent arrest notification. But for licensees right now, it's to enroll them in the subsequent arrest notification.
So the
program.
I'm sorry, but they couldn't have used the old fingerprints for that, or?
No, unfortunately, not all fingerprints were digitized, which is why we're coming to do this to ensure that they are all digitized consistently.
Gotcha.
So under the new program, if somebody is arrested, an attorney is arrested, fingerprinted at the police department, will the police department then send it to the State Bar? Is that
Yes.
what the notification is? So they'll
Yes.
like ask, what do you do? I say, I'm an attorney, and then they know to send it to the State Bar, and the bar is notified.
Actually, through the matching, the State Bar is notified.
Okay.
So an attorney doesn't really have to express the fact that they are an attorney. They
Right.
will get a match. And the other thing to know too is that we are not acting on arrests. The rules really are about convictions.
Right. And prior to this new initiative, if somebody was arrested and fingerprinted, would the bar be notified? Or is that why you changed it?
Yes, we relied on self-reporting.
Yeah. Well, good. More questions?
I have a question. How would this new fingerprinting affect our ability at the Board of Legal Specialization to make sure that certified specialists are abiding by the law always?
Okay. Well, I think for anyone, any licensee, when we get notified and a conviction is involved, that information will go to OCTC, and we will enforce our standards. And so, regardless of whether you're specialized or not, I think information will be communicated to the appropriate channels.
But there probably won't be a separate report on specialists. Like if you're a specialist, would there be a second report that would go to Natalie? Or...
It depends on what the privacy settings are. As to that, most likely it would go through OCTC, first of all, to make sure that it is an actual conviction
right.
rather than an arrest, and then it would come through which we already have a normal process that could be better informed as a result of
that. It probably works well. So
Yeah.
Probably doesn't have to change.
Well, and it'll go through appropriate channels as any disciplinary action that's taken now. So, in terms of information sharing, it would follow the same path that a disciplined attorney would.
Other questions? Back to you. Do you have more?
No, I think that's it.
it.
Yes,
And,
thank you.
And Natalie, were you done with the portion of the software you want to talk about now?
Yes.
And then there's more you're going to talk about later when we get through the agenda.
Yes.
Okay, so if everyone can turn to page 5 in their materials, the open meeting action summary from our April 13th meeting. And hopefully people have had a chance to review it. Any comments or questions about it before we vote to approve and accept it? None? We have a motion and a second to approve the open meeting action summary for April.
So moved.
I'll second.
All right. All in favor?
Aye.
Any opposed? All right, so those meeting action summary has been approved. Then turning to page 8 of the agenda, the financial and operational key indicators. And Natalie, if you can give an overview of what this shows, then we will move to receive and file these key indicators.
Sure. So I'm standing in for Neil Topper, who sends his regrets that he is not available today. You know, he usually presents this report based on his financial expertise and background. In terms of the financials, you have before you the operating statement through May 31st. Again, we are looking at financials by month, and the program is on budget. Your reserve investment spending initiatives are, of course, a part of these numbers, and so they look a little bit different this year than they do in most years, and that is proceeding normally. Because that involved new initiatives that we'll talk about in the closed session regarding exam development, those numbers are placed into the December portion. We are working on those projects, and we'll talk about them in a little bit of time in the closed session. But essentially, the program is on budget. Any questions about the budget or the operating statement? Okay. In terms of the number of total certified specialists, you're seeing an expected dip in the number of specialists. At this time of year, in these years, which are the even years, this is the period of time when there are not a lot of applications generally, because people have been waiting for their exam results. So new applicants took the test in October, they received their results in March, and most needed some time to create their applications. And so you're going to see quite a few applications for new certificates today. But also at this time of year, those that are retiring from practice generally will resign at this time of year when it comes time to pay dues, and rather than doing that, they might move to inactive status. So the dip that you see at this time, I believe it's temporary, and you will actually see an increase by September, and it is normal and it is expected. Any questions about the numbers? Also, in terms of legal specialist education compliance reporting, we now are getting very used to the new cycle, which matches the MCLE reporting cycle every 3 years. While people are getting used to it, there was a little confusion this year because legal specialization billing went from paper fee statement to online fee statement, and that actually caused some confusion with compliance. People thought, well, maybe the compliance is no longer the paper form, maybe it's online. And so we'll talk about that in a short while. For the tiny number of people that haven't complied yet, the staff is going to recommend that you give them a bit more time, but we'll talk about that shortly. Any other questions about the educational compliance reporting?
So do we have a motion to receive and file the report?
So moved.
Seconded?
Second.
All in favor?
Aye.
Opposed? All right, it has passed. Thank you, Natalie. Turning to page 20, this is the post-exam metrics. And let me start out by explaining what it is, and then Natalie, if you have any comment on these numbers, please jump in. But for people who took and passed the 2015 exam, approximately 77% as of July 1st had submitted their application. The remaining candidates have until January 31st, 2019. Then for the 2017 exam, it's about 26% who have completed their application. and they have until January 31st, 2025. Those sound like good numbers, but is that what we expected? Are there any comments on that data?
Yes. So you see two things that are newer trends going on. The first one is looking at the prior exam, 2 exams ago. You see that that number is a little bit lower than it normally is because you see more people taking the test in their 2nd, 3rd, and 4th years of practice than you did previously. I think people are now more aware of that. They're using that to guide their experience and to guide their study time. But as a result, they need a little bit more time to submit their application. But then the flip side of that, you see in the most recent exam, 25% were ready to file their application right away. We normally would be expected to be at that point by about year's end this year. So new attorneys are interested in this program, but also experienced attorneys have better access through the redesigned website to get the applications and prepare and submit their applications right away.
Right, any questions or comments on that? Miles?
No, I have no questions or comments.
Okay, you look like you were going to say something.
No.
All right, do we have a motion to receive and file the metrics report?
So I'll move that.
All right. And a second?
Second.
Any comments before we vote? All in favor?
Aye.
Any opposed? All right, it has passed. And turning to page 24 of the agenda, this has to do with the legal specialization annual fees and education compliance, which you had mentioned briefly, Natalie, and we are looking to extend, or the recommendation is to extend the compliance deadline to August 31st, 2018. And I think you started to explain why that is, Natalie, but do you want to explain it again since we're on the site?
Sure. Okay, so the specialist fees are billed in the fee statement. And last year in 2017, the State Bar transitioned from a paper fee statement to an online fee statement. The legal specialist program was not included in that transition because there was a fee waiver last year. There was not a need to bill those fees last year. So this year was the 2nd year for the bar at large, but the 1st year for legal specialists. And that caused a little bit of confusion, and there were a couple of hiccups in the system itself regarding some double billing that had to be credited back to some of the specialists and also the attorneys at large. So as a result, it took time to resolve those issues, but as well, others heard about that temporary glitch and waited to pay until the confusion was resolved, as you can certainly understand that. They also were further confused, wondering, hey, I have my paper compliance form, but am I complying with this paper form as I always have done, or am I moving online? And so some held their compliance. So I would encourage you to do what Member Services did last year, which is to give the attorneys an additional time, an additional 8 weeks through August 31st to both comply with education and to pay their fees. Very small number of people that we're talking about, but there definitely was real confusion, and it did definitely come about in part because of some of the actions of the law. So the staff recommendation here is to be reasonable and give them a bit of time. That timing will not impact the billing for the upcoming year, so that's part of the reason that that specific date is chosen.
Does this impact the next agenda item, the decision on, I guess, revoking certification for people who haven't complied? Or are they not affected?
It does not, because we actually pulled out those specific individuals pending the CBLS's action on that.
Okay, so we're not being inconsistent if we give them until August 31st and a later vote on this second?
No.
Good. So any questions or comments on the recommendation to extend the deadline until August 31st?
I have a question.
2018. Yes.
Do you think this will be the last time, the last chance? Or do you think we'll be back again in September getting it to consent?
I believe it will be the last time for a number of reasons. The billing issue was resolved. We have gotten in touch with the individuals. To wait longer would impact billing for the following year, and I do think by then we will have time to be notified.
Thank you.
So when you say it'll be the last time, if people don't comply, then they would go on this second list, right? And then we would probably we'd be voting on whether to revoke them after a 30-day period and a final notification, but there would be an extension.
Correct.
Got it. Rob?
So those that are affected will be notified, depending on how the vote is, that they have until the end of August.
Yes, so they will be notified on Monday if the board so moves. They will be notified if the board does not move as well. And so they're aware that this item is being considered today.
Any other questions, comments? Do we have a motion to approve extending the deadline until August 31st on both fees and educational compliance?
So moved.
Second.
Second.
All in favor?
Aye.
Opposed? All right. Moving on to page 26 of the agenda. There are two issues here. The advisory commission recommendations regarding certifying applicants in their advisory commissions. And that is attachment A, which goes from pages 28 to 64. And then the second issue is revoking certification for those in attachment B, which is on page 65 of the agenda. So turning to the first issue of accepting the recommendations of the advisory commissions, let me just give people a moment, if they haven't, to look through the pages, and then if there's any discussion on any individual advisory commission recommendations, we can have it, or if there is no individual discussion, I would propose we just vote as a group to approve or not approve all of them.
And I'll just confirm that these were distributed in advance as per process, and I did not receive any requests to train a specific individual at that time, though the committee may choose to do so today.
Okay. So I see people flipping through their pages, but do people want more time to look at these names, or since it was distributed in advance, are we good to go to the discussion?
Closed
Discussion.
All right. Is there a,
This says closed session.
Previously, these were in closed session. Recently, the Board of Trustees made a change based on the interpretation of the open meeting laws that these should be considered in open because you are taking the final action.
does it say closed session somewhere?
Yeah, it says closed agenda.
Closed agenda.
At the top,
We apologize.
the caption.
It must be the prior template that we previously used, and we'll correct that for the next meeting.
Okay.
Yeah.
Yeah, mine says open.
If one of us has our name on the bill, should we not read?
Well, I would,
Yeah,
I think
there's
it's
somebody
okay.
on page 53. Yeah, who's that guy?
so we'll assume any vote you have is abstaining from your own individual recommendation. Is there any discussion about any specific advisory commission and their recommendations? We have a motion then to approve, this is just attachment A, the advisory commission recommendations to certify all of the various proposed specialists on those pages.
I so moved.
Wait, I'm not done.
Oh, Bob's not done, okay.
It's a huge,
No rush. but
huge
let's-
amount of work comp.
Yeah, no,
And just
again, no
for-
rush, so just let us know when you are done. And
And just for the
Michael,
record,
you had a question?
No, I was just gonna say, just for the record, they've already all been pre-screened, pre-approved by the individual specialist committees.
Correct, so, and staff.
I'm good.
Okay.
So I so moved it.
I so
This is
second.
approved.
Okay, so
Second.
good to go, Bob?
I'm good. Second.
Okay, and I've already asked for any discussion, but is there any discussion for the vote? No? All in favor of approving all of these proposed specialists?
Aye.
Any opposed? All right, the ayes have it. So going to part attachment D, the revoking of specialists. This is on page 65. And remind us, Natalie, I'm sure some of these people we've spoken about before, but the people who we are going to vote on revoking, subject to them getting another notice in the 30-day chance to cure, have all or most of these people previously been noticed? Have we voted on it before, or is this a new batch?
You haven't been voted on them before. You're presented with the most recent for that particular month. So this is an administrative action. It's not, for example, as to discipline or failure to meet a requirement. Their recertifications were due. They did not present a recertification. The recertification date has passed, and they have been notified. So we're seeking administrative permission to revoke them for failure to meet an administrative requirement.
So these are people who just did not submit an application to
Yeah.
recert.
Right, and generally the process would be that they would resign, but here they did not do so, and as a result, they're not in compliance with their requirements to maintain a certificate.
And so what do you do then? You notify them that they're not in compliance and can no longer hold themselves out, or what's the next step?
Right, so we advise them via certified mail of this, and that the action will become final within 30 days, and it will automatically become final if they don't produce their application.
And they've all gotten that 30 days.
Yes.
Well, they're getting another 30-day notice.
I'm
I mean,
surprised.
they've gotten, as I understand it, they've gotten notices it was due, but they're gonna get a further 30-day notice after today with another 30 days. They're not being revoked today, right?
Right, and we shouldn't talk to us as to the personal circumstances of anyone as to this here in this forum, because it's just simply administrative.
Okay.
Mm-hmm.
Yeah, there will be another notice.
Okay,
Go
yeah, I
ahead,
know
Bob.
one Paul Magdalene.
Yeah,
that's-
so we.
Yeah, we're not talking specific people, but,
I know, I'm very surprised by
yeah.
that one. I can contact you.
That won't be necessary, it's administrative.
Yeah. So any further questions or discussion before we vote?
So we're voting on making their revocation effective 30 days past the next letter notice.
If they don't correct.
So we're not gonna have to vote on these same people again.
No, you see them one time.
Okay.
Yeah, and I had asked that because this has some dates in 2017, so I didn't know if that was a carryover of somebody we might have talked about, not.
Oh,
talked
no,
to.
that particular person had an extension, and the time had passed.
Okay.
And that was the original.
That's why it's an older date.
Correct.
All right, do we have a motion to approve the recommendation to send a final 30-day notice and to then revoke them if they do not cure within the time of the 30-day notice?
So moved.
Second.
All in favor?
Aye.
Any opposed?
And
All right.
thank you, that's an administrative reminder to me that if someone is outside of the time frame, I'll provide more explanation next time.
Okay. All right. So let's do one or two more items that I'm gonna, we'll take a break at about 12:10 so that we're ready for when Richard calls at 12:20.
Terrific.
And then, yeah, we'll recommence. He's just gonna call in, so we'll hear him dial in and answer, and then we're gonna do some. Okay, so, we're up to page 66, the interim advisory commission appointments. And there are recommendations to appoint people to bankruptcy, legal malpractice, and workers' comp. And there are attachments A, B, and C, which describe people who are recommended. Do you have anything, I know Admiralty's not on here, do you have anything you want to add here, Natalie, or explain? why
Sure.
Admiralty is here, and about the three that we're recommending.
Sure, so Admiralty is collecting applications, but they've completed their meeting cycle for this year. So applications will be presented to you at the next meeting in September, and have everyone appointed then so that they can be trained together since their work is done for this year. But certainly the recruiting will continue. As to the others, just to differentiate, each year you make appointments for full 4-year terms. These are people, these are terms that are open because someone was in the midst of a 4-year term and needed to resign for one of any number of reasons. So the advisory commissions took a look at the applications along with staff in the first instance. They did what you asked them to do. They used a structured process in which they determined which areas of expertise were needed and how to bring diversity of point of view and geography into the commission. And these are the product of that. Sometimes at interim appointments like this, you see terrific candidates that are chosen, but also terrific candidates that are not chosen. And sometimes that's because those candidates are slated to be presented to you in September for the full 4-year terms. If someone is appointed to a partial term like this, they would be eligible to apply for a full term after that concludes.
All right, so in bankruptcy, under attachment A, Joseph Ufadel is the recommendation. For legal malpractice, which is attachment B, it's Dan Stanford. And for workers' compensation, attachment C, it's Nikki Jacobson. Any discussion about any of the recommendations for any of the commissions?
I just have a general question.
Yes.
My question is, because many of these candidates are really excellent, the ones who are not chosen for the interim position, will they be notified and made to understand that they should apply for the full 4-year term position starting next year?
Absolutely.
Thank you.
And do the commissions, like, would they differentiate and only contact the ones they think are excellent? Or will they contact everybody and encourage everybody to reapply?
They will contact all equally.
Okay, and it's the commission, not you and your group? or
No, it's
both?
me. It's an
It's you.
administrative function from the state bar.
So you'll call people and thank them?
We'll send a letter.
Okay.
So if a position opens up later, like say next year position opens up, the people that have applied this time, are they automatically considered for that position, or would they have to reapply?
Reapply.
We contact them to see if they're interested to, I want to say reignite, that's not the right word.
Reinstate?
Reinstate, yeah, their application for consideration in the following year, because possibly they're interested but not available that year. And if they say yes, their application becomes available, but we're also given the opportunity to update it.
Yes.
Could we, I mean, I don't know if this is something that we want to consider, could we have something like, essentially like an extra check box for somebody's application that says, could you please just keep this on file and consider me for the next one, subject to any kind of, I mean, it just avoids that one step. We could have people that just kind of like drop the ball on it.
We could, but the reason that we don't do that is because, first of all, in the future, they may not be available.
Yeah, they might not want it.
And then also, it just goes through the standard state board checks, discipline, eligibility, other things like that. And so that's why we do it each time.
Okay.
Any other questions or discussion?
Just for the record, I thought everyone who was on this entire list for all these interim appointments was excellent, and I commend the Law Advisory Commissions for doing a wonderful job in selecting and giving us information I don't see.
Great. Does anyone want more time to review it? I see Bob, you're looking through it. Are we good to go? Any further discussion? Or if not, let's have a motion to approve.
I move that, so moved, be approved.
Second? Second. All in favor?
Aye.
Any opposed? All right.
And I recommend this is an appropriate time for the approval.
I was going to say that because I think the Ames report will take more than 3 minutes. Right?
Good guess.
Okay, so why don't we take a break? stay close because Rich, who's going to be our guest, will be calling in about 15 minutes. And we want to be respectful of his time and start as soon as he calls in. So I guess we're off the record.
we should get him on first. Because we have technical.
Hello, this is Richard.
All right, hello Richard, it's Glenn Plattner, we talked briefly, the chair of the committee.
Yeah.
And we are back in open session, so I hope everyone enjoyed their break. And I want to introduce Richard Schaffler, who is a senior program analyst at the State Bar of California. He's up in beautiful San Francisco today with multiple meetings, so he apologizes for not being able to join us in person, but we look forward to meeting you at a future meeting. And Richard went to my alma mater, Berkeley, and also has a degree at Johns Hopkins. And you know, I'm aware of what you're doing, Richard, and we definitely appreciate your looking at our board and how we do things, and we look forward to your recommendations, which I understand are still in progress, so we're not receiving them today. But we appreciate your taking your time to review everything and to speak with us today. And before we hear from you, I'm going to turn it over briefly to Amy and Natalie, who are going to give a little bit more background on what this process is and what Richard has been doing.
Great. So to ensure that we're all on the same page about what the origin of the Appendix I is, as well as how it's interfaced with the CBLS, Natalie and I are going to just give you a little background. So Appendix I, or the review that's associated with Appendix I, originated from the Governance and the Public Task Force, who directed the Board of Trustees to make recommendations on how their sub-entities function. That task force is tasked with looking at ways of enhancing the protection of the public and ensuring that protection of the public is the highest priority for the State Bar in licensing, regulation, and the discipline of attorneys. And so what the board has been directed to do is to look and review that all sub-entities do the following. The board's been directed to look at to ensure that the board fully understands what each sub-entity functions under, including for us, the CBLS, to determine whether the board has the information it needs to oversee the sub-entity properly and adequately, and also to evaluate the effectiveness of how each of the sub-entities function. And lastly, to focus on whether the board should segregate any administrative work that is delegated to any of the sub-entities for staff, so that there is a distinction between what is administrative and what is a sub-entity function. And so what that means for the board itself, it's overseeing the sub-entities that pretty much are handled by over 200 volunteers statewide. So the board is having to do this for every sub-entity that works with the State Bar. So these recommendations, need to have some consistency, some guidance, and they're guided by what the statutory authority that is granted to each of the sub-entities as well. So as you can see, the review process is comprehensive in the sense that it's looking at the function, it's looking at the statutory authority, and it's also looking at the efficiency involved in that. And so I think what's very important to understand about the process and about this initiative is that it's really not formulated to be a punitive process, but rather one that is looking at, in a model, in an optimal environment, what would be the best way to carry out each of these functions. And that's really what this is stemming from. And Natalie's going to give you a background on how the CBLS has been engaged in this process.
Sure. So because people have come on the commission at different times, just to make sure we're on the same page, the Governance and the Public Interest Task Force met some time ago, and some of the members here actually watched the cut of the tape from which they did a live discussion and the report issued. Over the course of the years, you've discussed various initiatives. One became what was ultimately the Reserve Investment Program that we'll talk about in the exam development in closed session. That was a function of this process. You also had a visit from members of the Board of Trustees. You also had a visit, actually not from Mr. Schaffler, but his colleague Andrew Conover in the Office of Research and Institutional Accountability, who stood in for Richard. He was not available on the specific day that the meeting was happening. Richard and I have had extensive conversations about what the staff does on a day-to-day basis. The General Counsel has weighed in about the enabling authority for this program, which you know is Court Rule 9.35, and what the court is looking for through that rule. So all of these things are things that have happened so far. And also just be aware that this is a new type of process. Self-evaluation is not new. This board does that all the time. We've really produced many different innovations over the years that I've been with you. But this particular Appendix I process is new. So the process was set out, but also some things are adjusting as time goes on based on what's being learned so far. And Richard is one person who is involved in all of the reviews with all of the commissions. So I'm interested to hear what it looks like from his point of view.
All right, Richard, so with that, the floor is yours. You have a room full of all of the CBLS members, Amy and Natalie and Adrian, and I'll turn it over to you.
All right, well, thank you very much. A pleasure to be with you today telephonically, and again, sorry I can't be there in person due to the lucky Friday the 13th collision of multiple sub-entities meeting at the same time. But I do want to also point out at the beginning that Natalie and Adrian have been terrific in terms of bringing me up to speed and explaining the details, nuances, and evolution of what you have been doing in terms of legal specialization in California. I'm here at the bar working exclusively on this. We are looking across the 9 sub-entities of the bar, which include every sub-entity that's left out there: the Committee of Bar Examiners, the Lawyer Assistance Program, the Mandatory Fee Arbitration Committee. All of them are, the board is trying to take a look at, as was mentioned by Amy and Natalie, its governance role and how can it be sure it knows what's going on and to make sure the bar as a whole is moving in the same direction. As we know, California is a very large state. It has the biggest largest number of active lawyers in the country. So, and the geographical and demographic diversity of California is both enjoyed and great. I speak as a native Californian born in Long Beach, something we all enjoy, but something that from a governor's perspective, it makes it complicated. So what we're doing in this review, as Amy alluded to, is we're, first of all, trying to get the facts straight. One of the things I think I've discovered, and maybe not surprisingly, is that there's uneven levels of understanding both within the bar and outside the bar as to what each of these sub-entities does and why it does it that way. Most bars around the country do a similar set of things, but some of them, only one of them really, they do almost identically everywhere, and that's the Client Security Fund. Everything else really varies quite widely. Sometimes that's because of whatever the legal authority that established that function in that state. Sometimes it's just that New England states tend to do it this way and others look in a different direction. So the first order of business has been to get it straight, and Adrian helped by providing some nice flow chart. So my first charge is to make sure the facts are straight. Because sometimes I think what happens is people have friends, colleagues, professional associates in other states, and they hear things and think, gee, why aren't we doing that way? We should be doing it that way. Or this sounds like yours is very discretionary. I wonder why we're not using our discretion. It might turn out that California's framework is totally mandatory and doesn't allow for a lot of discretion. So the first thing is to get that straight. And then the second is the board is asking this set of governance questions. So the descriptive questions are really, what's the legal foundation? How does the board exercise its oversight? what is the structure of the sub-entity, what's the division of labor between the sub-entity and the bar staff, and then comparatively, how does that compare to how other bars do it, whatever that happens to be. And then additionally, there are a set of factors that are what you need in order for any commission, committee, board, subcommittee to be effective. There are certain characteristics that need to be in place. Briefly, those are clear role definition for what is the group supposed to do, what the mandate, what's the scope, how is the work of that group made accountable and transparent, how does it report on itself, to whom, how frequently, with what information, clear lines of authority, what does the group have the authority to do, what must it make recommendations to a board in order for the board to approve those and authorize whatever that action is. The idea that these bodies make impartial, consistent, and fair decisions as another key important feature, and lastly, that the volunteer lawyers, public members, and bar licensees are actively engaged and understand what's going on. So I think it's fair to say that so then to give you a view of, before we get to your work, thinking about these functions that different volunteer sub-entities have in regulatory organizations. If you look across California state government, federal government, other states, all regulatory bodies, whether that's the EPA, the SEC, or the bar, good ones, try to incorporate the participation and perspective of the practitioners or the industries that they're regulating, for this obvious reason perhaps that the real world experience and expertise of those people needs to be brought to bear on the work of that regulatory body, so that whatever policies, procedures, regulations are established make sense in the real world. Excuse me. The bar, compared to other regulatory bodies in California, makes very extensive use, much more extensive use of volunteers for licensing, regulation, policy advisory, certification, wellness, education, accreditation, adjudication, arbitration, and grant making. Most regulatory bodies utilize volunteers for policy advisory reasons and licensing reasons, but they tend to convene smaller, more dynamic groups, task forces, or working groups to work on specific issues, and then to thank those folks and not maintain standing committees. So that's really one of the things the bar is wrestling with, is where do we need standing committees, and where we need them, how should they be composed, and what's the division of labor between that committee and the staff, and where might we be better served by having these sort of focused groups. So to make the point slightly differently, the bar has, currently we're looking at 9 sub-entities. The Board of Accountancy, which regulates accounting firms and individuals, has 4. Board of Nursing has 2. The Medical Board, regulating doctors, has 2. So we have a lot more sub-entities. Plus, the total number of volunteers that are engaged in this is, for the bar, is about 254. The next nearest regulatory body in California, it has 40 volunteers. So you can see the bar has a much different structure to it. And that's neither right nor wrong, but it does give a sense of perspective. I think each sub-entity naturally thinks to itself, well, here we are, there are 16 or 14 or 25 people, what's the problem? But when you add it up, it creates a large infrastructure, and the board is asking, is that the right infrastructure? If we were to start from scratch, would we build it this way from a governance perspective? And again, because your work, in my impression, is fairly clearly circumscribed. You have a pretty clear function. You have a pretty clear way you do it. You report annually to the board, and Natalie has shared those reports with me. So you might not be aware that not all these sub-entities have been reporting annually. That some of them used to, but then stopped, but nobody quite knows why they stopped. Not all of them have metrics as to what their work, what are the outcomes of their work. So that creates an issue of how does the board know whether the program is being effective and having the intended result that we want. Sometimes some sub-entities have very clear decision rules about about the work they do, document those policies and precedents and decision rules so that they can ensure consistency and fairness over time and as the composition of the board or commission changes. Others do not. So there's an inconsistency within the bar itself as to making sure this work is happening at the most efficient, effective, and professional level that it needs to do. Not because anyone is trying not to do that, but only because in all cases in a big organization like this, it hasn't been governed to ensure that consistency is being practiced everywhere. So, some of in terms of lines of authority, some sub-entities have thought that the best way they could advance the work that they're supposed to do is to, let's say, file amicus briefs or engage in legislative advocacy, sometimes without the awareness of the board, much less its approval. So you can see how that might create issues when the board goes to the legislature and says, hey, we'd like, our position on this is X, and they say, well, really, because we've heard from this group of yours that your position is really Y, and we heard from this other group of yours that your position is really Z, because this work isn't being overseen effectively by the board. So some of those are easy fixes, just reinstate the reporting, clarify the lines of authority. Others of them are perhaps not so simple. So that's sort of the big picture of what the board is doing and why and how, although they may not be visible to you in your own work, hopefully you have some appreciation of what the governance issue in practical terms is about. I'll stop there before. So this is not a downsizing, budget cutting exercise. I have not been instructed to achieve any reductions, or it's really driven by effective governance of the bar as a statewide organization. So I'll stop there briefly, see if there's any questions before we get to your work.
So any questions? Let me look around the room. Anyone? All right, Richard, it looks like we're good to hear the next part. Okay, so I think with respect to the board's work, your board, this is going to be confusing, not the Board of Trustees, but you guys.
Richard, what I might suggest is you might use CBLS, the
All right.
California Board of Legal Specialization. Maybe that would help.
Will work. That'll work. So with respect to CBLS, I think there have been 3 ideas floated in terms of how to accomplish the work. Status quo, let's continue to use CBLS and its specialty advisory commissions, and maybe there are ways to do that more efficiently, process improvements, or different ways that could be somewhat streamlined, because I think, from the outside looking in, you have a CBLS of 15 members, and then the 99 volunteers on each of the 11, the 9 volunteers on each of the 11 specialty advisory commission. So that's a lot of people, it's a lot of meetings, it's a lot of, and the question is can we make that in any way more efficient? So that's one option, status quo, maintaining and streamlining. Another would be, should California outsource all of legal specialization? Obviously, as you know, that private ABA accredited organizations are used for certain things. If that option were chosen, it would leave 8 current legal specializations that the CBLS is responsible for, not provided by any current private provider. Another option floated is that, well, now that the 16 sections of the bar have been separated from the bar into the California Lawyers Association as an independent nonprofit, perhaps this legal specialization certification function should move to the sections. So those are the 3 options floated out there. There may be others, or there may be hybrids of these, or and again, because this isn't a cost-driven exercise per se, Natalie has made clear to me what the revenue implications of the current and any alternative scenarios are. So I think those are known, and I guess we could set those two aside, as the board will obviously have to take that into consideration. But they're really trying to get the best thinking on what's the best way to organize this. So that's where we are, and I'm anxious to hear from you as to your thoughts regarding legal specialization in California and how to best conduct it.
Richard, could I ask, if it's not cost-driven, what do you think would be the number one factor behind any potential changes?
I think it's governance, which sounds very abstract, but it's really so if you think about it, I don't think it's a secret that relationships between the legislature and the bar have not in recent years been the greatest, and the legislature's perception has been that the bar has not been well governed, well managed. Right or wrong, I'm not here to say, and I don't know, but certainly there's a notion that the bar needs to get its house in order. So, and that's fine, but so the question is, what does that mean? And hence, that was the purpose of that task force, in a sense, was to really take a look at, well, how are we governing ourselves, and how should we govern ourselves to be an effective bar? And to put that in context, bars are curious. I'm not a lawyer by training, I'm a sociologist, so I look at this kind of, I said, almost like an anthropologist coming into a village of lawyers and asking, like, wonder why it's that way. And bars had 2 interesting and somewhat confusing contradictory functions historically. One was the regulation of the profession, and that's licensing, discipline, the bar exam, the state bar court, and all that. And the other was sort of trade associational, promoting the profession as a profession. And if you go just on tour of different state bar websites, you'll find that reflected in things like, oh, hey, here's your LexisNexis join, and you get these discounts on legal services, on office supplies, you get free this, free that. So those are all sort of membership benefits, if you will. Then there's the other side, which is the client security fund, the fee arbitration, the bar exams, and all the regulatory pieces. And then there's things that arguably are neither one nor the other, or can be seen differently. I think it's fair to say that in the legal world, with respect to legal specialization, there are some that view it as an important public protection function insofar as it seeks to ensure that people claiming expertise in an area of the law actually have it, or can be shown to have it. And I think there are others who say, well, this is sort of a way that lawyers can, in a sense, enhance their marketability, And so it's really not a public protection thing, it's like a membership benefit. And if you look around at state bars, they range from ones that actively promote specialization to ones that, all the way at the other end, that prohibit anyone making a claim at all to any specialization, to in the middle are ones that allow it but don't endorse it and have disclaimers about it. So there's not one mind about what it means. And obviously, as in many of its functions, the California bar has a very robust version of that compared to other states which seem to have a lower standard, if you will, in terms of the requirements that you need to meet to get it. So I think the board is being driven by trying to understand, the threshold question: should the bar be doing this at all? If you look around some of these functions in grant making, many state bars have chosen not to house that inside the bar itself, but to have that done by a bar foundation that's a separate entity entirely. If you look at lawyer wellness programs dealing with substance abuse and alcohol and perhaps even mental health issues, many of those have been located outside the bar. So it's really the board is really looking to understand, okay, what do we think? What would be the best way to do this for California? It's not necessarily driven by if 35 states do it, then we should do it the way 35 states do, obviously, but they're really just asking the question of, well, what is the regulatory body we're trying to become, and what should that look like?
So since Richard's not in the room, this is Glenn speaking, let me sort of lead the questioning, and I'll have people introduce themselves. Everyone will have a chance to ask questions. And let me start. And first, Richard, thank you for everything you've said so far, and let me tell you my thoughts, and then I do have a question. Probably not surprisingly, I would favor of the three options, the status quo, but with any improvements on efficiency and operation that you and the Board of Trustees recommend. I mean, we're always looking for improvements, and we've gone, over the years that I've been part of this, from having probably 30 people in this room to a much more streamlined group, and we've streamlined the various advisory commissions. And the reason there are so many is we have determined, and I think the Board of Trustees agreed, that because there are 11 specialties, you can't really have a franchise lawyer like me figure out what is right for admiralty or family law or other groups. And therefore we had recommended, and the Board of Trustees have agreed, that this individual advisory commissions are working. The status quo seems like the right choice because our board is a program that is working. It has been working not only financially but also for the stated objective and the objective that we talk about at every meeting of public protection. Our board and the fact that it's done through the state bar ensures the educational requirements to make sure somebody actually qualifies as a specialist, the experience requirements, and also the discipline if somebody is straying from what he or she is supposed to do as a specialist. But all that said, I'm certain we're not perfect, and there are ways that things can be further improved and streamlined, but without sort of blowing up the program and doing one of the other two options. So the question I have, if you're able to answer it, and I know you're about to issue a report, you've been working on it for a long time, to the Board of Trustees, so you haven't necessarily reached final conclusions, and the Board of Trustees certainly hasn't weighed in yet since it doesn't have your report. But are there any preliminary thoughts that you can provide on what you think we're doing well, or where we could improve, or your initial thoughts, preliminary thoughts on recommendations?
That's a great question. And I think again, Natalie's done a very good job of educating me about this and about how it's done and about the improvements that have been made. So I certainly have the impression that this has been a very consciously led sub-entity in the terms of trying to be aware of what it's doing and how, and and how to do it in the most optimal way. So, I mean, quite honestly, I don't know. I mean, my job is really to tee up the questions and options for the board and to have them make the decision based on the right understanding of the work of the board and what it does and how it does it. And you know, I think the question as an outsider looking in is, and this is not just pertaining to this subentity but others. So, you know, question is, what can we do, or what do you all think about the relatively low level of participation of active bar members in getting specialized? I mean, we have the same issue on the lawyer assistant side, where we think there is a much bigger, I mean, those in the field believe there's a much bigger set of lawyers that need that kind of help than are currently being served, and that kind of raises the question, well, are we the right ones to serve it, or what are the issues there? Here, it's like, if the national average and the California average are that, you know, of active attorneys, about 3% take advantage of becoming a legal specialist. Maybe that means we're not doing a good enough job of marketing it. Maybe it means they don't see the benefit. So I guess that's a question I'd really be interested to know your thoughts on.
Well, let me start on that. It's Glenn speaking again. I'm used to doing these court calls where you always have to introduce yourself, so I'm used to just saying my name every time I talk with someone on the phone. But I mean, my take on that is that the overall percentage of attorneys is probably exactly what you said, 3-4%. But to me, that's more what causes that is that we probably could use more specialties. And you know, if we had personal injury or landlord-tenant or various other specialties that have been talked about with this board, but we've been sort of encouraged perhaps not to expand it that much, there would be a much higher percentage. I mean, you would never want too many specialists, otherwise it kind of dilutes it if you have 60% of the attorneys as specialists. But within the actual fields that we have, I'm in franchise, I think there is actually a very high percentage. So somebody who's looking for a family law attorney, it's certainly higher than 3%. So you know, that's how I see it, that you know, within the 11 that we have good saturation and probably a very good percentage. It could be higher overall if we expanded the number of specialties.
Yeah, and then to your point, there isn't, since the bar doesn't ask people to declare what kind of law they do, the nearest proxy was looking at who has elected to join the section. So you're right, in family law, the section, number of section members, 3,921. The number of certified legal specialists is 1,400. So that's about 36% of the people. In taxation, it's about 10%. Workers' comp is about 35%. And trusts and estates, it's about 16%. So that's kind of a proxy, imperfect measure, but makes the point that you're making. So I've included that information in the draft to try to make that clear.
So let me turn it over to other people, either to answer your question or to ask their own question. And let me just kind of go around the room. I see Jeff, Hayden, your hand is up, so do you want to speak first? Yes. Oh, well, Natalie wants to say something first.
Richard, I had a process question too. So we did a cover preview of what would be discussed today. So some of the members might want a little bit of time to think about it or ask for staff research or bring some data in, rather than asking a question today. If that is the case, are they able to do that? They could, in compliance with Bagley-Keene, submit their suggestions or requests for research to staff, and then we could share them with you. Is that okay?
That's correct. So the best way to do that at this point would be to send them to you and for you to send them to me, and then I will gladly then circulate the draft of the description and so that make sure that everyone, I mean, then people can comment on that draft. So we have, you know, this needs to be finished by the end of August. So I can certainly send the draft to you, the current draft to you, Natalie, so that can be distributed to the members for review and comment in addition to this discussion. Just noting that, of course, sidebar conversations about that are not in conformance with Bagley-Keene, so they would need to read it and then send you their comments or concerns, and then from you to me. So yeah, you will. I'm eager to get this out to you so you can see. And I had a few outstanding questions for Natalie that she's aware of. So as soon as we can get that out to you, we will do that.
And I'm happy to take on that coordination role, so I would encourage any questions that might arise or questions where you have a thought but you want some data or some time to submit that through me, and I'll happily aggregate those.
Okay, so let me again lead the questioning, and Jeff Hayden, who's the former chair, had a question. Go ahead, Jeff.
Good morning, Richard. I was wondering if one of the considerations you're looking at when we're discussing numerosity, I mean, I joined Glennon's earlier comments, and one of the things that struck me as we're talking this morning is looking at the 11 areas that we're now looking at and certifying, and looking at some of the others that are out there that we haven't looked to. But have you looked into whether, for example, if there's a way to certify something like general torts? Most people that go to their lawyers might be looking at a car accident or a slip and fall. To that entity, there's also another group that would defend against those same cases. It's going to have a large number of lawyers that do those things, but there may not be an effective way to really see who stands out in the same way, certifies, generate standards, really differentiate them and regulate them in the same way that we can. It may not have that same level of consumer protection. I don't know if that's something you've looked at or that might be considered.
No, I have not thought about it that way, so I welcome any thoughts you have about how to go about that.
All right, so let me just look over at this side of the room. So Miles Friedman, go ahead.
Hi, I'm Miles Friedman. I have a question for you. I just want to compare, let's say, the legal side of the state as against the accounting side of the state. I have a background also as a CPA, so let me ask you this question. In comparing different, at least the State Bar of California Board of Legal Specialization to the state the state agency that oversees accountants. Does the state agency that oversees the accountants, to your knowledge, have a specialized committee, or is that really conducted by the American Institute of Certified Public Accountants, which is what my understanding is?
Yeah, that's correct. I mean, so the Board of Accountancy, as I look at their org chart, website structure, they're using, they have 3 sub-entities. One deals with licensing, one regulation, one with policy advisory issues. And then you're right, there are other entities that do the other function. And that's similar to the fact that, you know, the medical board, the doctors, they don't accredit medical schools like the bar accredits law schools in California, and there's reasons why California does that, and there are good policy reasons in my personal opinion, but so that's not a function that the medical board has, whereas it is one that the state bar does. So does that answer your question?
Yes, in part. So following up on that, so when you compare the State Board of Accountancy and the medical profession state board, when neither of those two have sub-entities that certify specialists either in taxation or, let's say, pediatrics, whereas this state board is certified specialist in several different areas, is it fair to be able to compare the numbers of committees or whatever that those boards have with the number of people that really have to work on the legal specialization side?
Yeah, I mean, that's a fair question. I think the purpose of that little sketch and is really a sort of a sensitization question. So in the sense that it's always difficult for people in any organization to try to imagine, well, how would we look different? And so one of the ways to try to illustrate some of the differences or ways to think about it is to look at other bars. So that's one issue. How do other bars handle some of these same functions? And then the other is how do other regulatory bodies in California do it of the profession? So it's not, it's largely like a thought exercise rather than there's not some strict logic operating there that just because we have more doing more, that makes that by definition an incorrect approach. So it's just to try to give people a comparative framework for looking at it. And just as trying to formalize some of the dimensions of governance allows the board to ask kind of systematic questions of itself and of the sub-entities. So the accountants also regulate firms. The bar doesn't regulate law firms. So that's an interesting question, whether that would make any sense. In England, they've gone, just as an aside, to a framework that actually tries to regulate firms and believes the firms will then regulate their own lawyers. I think there's a lot of different opinions on how well that works, but anyway, and that's outside the scope of this review. But is that responsive to your question?
Thank you very much. Yes, it is.
All right, so let me continue going around the room, and obviously, as Natalie said, not everyone has to ask their questions today, but looking for the next person who indicates. Roy, go ahead.
Hi, Richard. Thanks for being with us today. I really quickly, in terms of, I have a couple of questions. The first one is about the options that were listed out, like theoretically going with like a maintained but streamlined status quo, perhaps going to all outside providers or carving it out to the sections. As you pointed out, like there's some states that just don't allow you to claim you're a specialist. Just say, look, we're not going to have this, and we don't. Am I correct to presuppose that that's not an option on the table right now for California?
I don't think that's one that has been, that has not been raised in any of the discussions I have been part of, no.
Okay, so California would remain, regardless of how this shakes out, it's supposed that California would remain in the certification of specialists one way or another.
That's the premise I'm operating on, yes.
Okay, and I just had another question. Has anything come up, and I know you're in a preliminary stage of just like you have this mammoth task in front of you, and you may not have an answer to this, but is there any particular question that's come up about the structure of the CBLS and the commissions vis-a-vis our critical purpose, the public protection purpose? Is there any concern other than the fact that there's just too many people involved, for instance? Like, is there any, has it come up to you that, like, is there any worry about the public protection purpose of us, or is it an efficiency issue?
No, I think it's, no. So the short answer is no. There's been no question to me as to or suggestion, anything. I've learned that there's issues about the quality of the work being done. It's more, how are we doing it, and is that the best way?
Okay. All right. Thank you.
All right, Bob.
Hi, it's Bob Fermes. So if, hypothetically, we went outside, independent, think, who would we report to if we were outside, independent of the bar itself?
I can speculate on that. So you're thinking about the option, aligning this with the sections now part of the California Lawyers Association,
right.
That version?
Yeah, just in.
Yeah, so I suppose you would be part of that entity, and then it would be up to them to figure out how that would all work. And understand that when the bar transitioned these sections to the Lawyers Association, there was sort of bridge funding supplied by the bar. In other words, it wasn't sink or swim or, hope it all works out for you. There was a responsible strategy for, making that a successful way to go. So I would imagine that there would be something similar in terms of this, although you guys have the added benefit of generating actual revenue, so there is that. How that would get divided, I'm not sure.
Right. Okay, thank you.
All right, continuing around the room, any, I guess, Jeremy, go ahead.
Yeah, hi Richard. I'm
Hi.
Jeremy Klein. I'm a certified specialist in family law. So I was very interested in the statistics that there's a high participation rate in family law, as well as some of the other specialties. And I think I can tell you from the practice perspective that the culture has changed, that people, lawyers who practice family law, if that's what they do or what they're looking to do as the majority of their practice, do look to becoming certified specialists, that judges are aware of it, that they recognize it, they look for it, that certification is well known within the family law arena. And I was wondering, in your review, are you also looking, what can we do to expand certification or increase public awareness so that we can fulfill that public protection function? Because I think the board has been a little limited, that because of all the other things going on with the bar, and again, as you say, putting aside whether the legislature's perception is correct or not, that those things have been a distraction that have put certification or expanding it on the back burner. And I'm wondering if there's any discussion of what can we do to get past those distractions and look at expanding a successful program.
Yeah, great question. I think, I think part of what the board and the, management team of the bar have been trying to do in the last 2.5 or 3 years is to really demonstrate, hey, we hear you, and we are going to demonstrate to you consistently how we are managing this organization in a different way. And so they are, I think, doing everything they can to do that and make themselves more accountable and part of conversation, to embrace critics of the bar and enter into dialogue with them and ask them. So I think they're trying to do, in a way, the same thing as a board, is say, okay, we have to be a board in a different and better way than perhaps the board historically has been, or at least was seen to be. So, and part of that goes to, trying to use the data we have and to get more to answer questions like yours. I mean, I'm really interested to know, for example, I would be interested to know if I were trying to manage this program area of specialization, who are the people who become specialists? What is the view of law firms with respect to these credentials? I could speculate that, well, because a lot of consumers are seeking directly, practitioners of family law, and because a lot of those consumers are, located all throughout the state, and so when they go shopping, so to speak, for legal services, it's a high value thing to know, to them to know, okay, this person has been vetted by the state bar, so given it. And I wonder what drives, if you will, to put it in sort of economic terms, the market decisions of different kinds of legal clients as to whether that's a piece of information that they think is useful and valuable to them about that lawyer, or are they driven more by credentials of the firm, or the won loss rate of the firm, or is it all just personal? You ask the 3 people you trust the most, and you kind of pick one of the people they recommend, like a plumber. But, obviously it's a much more serious decision than that when people are in court, so you're hoping that they're they're making a really well-informed decision. And so I think, again, looking across all the sub-entities, I think I can see opportunities where there's certain things they all need to do better, let's say, and one of those is marketing, right, is outreach. I mean, lawyers by profession are not PR people, they're lawyers. So you'd want to think about a way, if I ruled the world of the bar, to really get the subject matter content from the experts like yourselves, and then figure out how to marry that up to, distance education providers or adult education providers for educational and training pieces, or to marketing people for how do we market this better. That's a big challenge. It'll never be, it's an ongoing and perpetual one, but making sure that the public understands and appreciates the value here, I think is a big challenge that the bar as an organization needs to figure out how it's going to meet that challenge for a lot of what it does, so that the public can take advantage of these things, and lawyers themselves for that matter.
Yeah, that's where I think the specialization has been underutilized, because we're the people who are committed to a particular practice area. We're the people who go through additional education to become certified. And yeah, the challenge has always been to get that word out to the public that there are people out there who know what they're doing, that there's more to the bar than just the discipline side.
Yeah.
All right, let me continue around the room. John?
Oh, Richard, this is John Monsell. I thank you for being with us today. I was sort of making notes as I was going along, but as I made the notes, a couple minutes later, someone would say something that would be almost identical to what's in my notes. So I'll try to just go through them quickly, because I don't want to repeat too much. The one thing that strikes me is this issue of governance. You said the key issue that the board is concerned about is governance. And the specialization program, since its inception many years ago, has been exactly that. It's a regulatory function. It's a way for the bar to regulate attorneys post-admission to the practice of law. There's a certain element in how attorneys function that they go through law school, they take the bar exam, and then they're just released on the public. And we do have now MCLE, we've had that for some years, but it's not focused on any particular field of practice. The attorney isn't required to take subject areas that are related to what they're practicing in. It's just generic, get your 25 units and you're done. So in some sense, that really doesn't do a very good job of protecting the public. And if that's the bar's main function, is public protection, then it seems like moving a program to either independent outsourced entities or to what is now essentially a trade group, which the sections are in, is basically the bar relinquishing that governance, that control over its members. And I think, which is a point that Jeremy was making about this discipline, and you made, Richard, that the discipline is sort of like the last result, right? It's basically, we're going to, as an entity, we're going to punish the lawyers in order to protect the public. So we're going to wait till somebody does something really bad, and that's how we're going to protect the public, instead of making sure that the people who are delivering services to the public are constantly improving themselves, which is what the Board of Specialization program does. The other thing then for the public, which is this other view, the confusion for the public. If we shift this regulatory function on this improvement post-law school over to either all outside entities or this independent entity the sections are now in, we have multiple groups then that are delivering services and supposedly protecting the public, and the bar has lost control over them. The bar needs to be the central control. It needs to be the governing body. For example, this outsourcing, we already do that. We have independent entities some in areas that are similar to ones we already have, and others in areas that we don't have as a board ourselves, that we authorize in the state of California to certify people so that we can tell the public we're being protected by these entities and their certification process. But if the bar shifts that off to the Lawyers Association, or just independently says, okay, entities, you can all do this on your own now, you make up your own rules, we're not guaranteeing that the public's protected. Thank you.
All right, so Richard, do you have any comment on that?
Only that it was very well said. I've taken notes and understand I'm going to try to reflect all of these committee concerns in the draft going forward so that those are noted and made, that the board is aware of them.
All right, well, we're more than halfway around the room, so let me continue. And Lou, do you have anything?
Good afternoon, Richard, and thank you for doing all this hard work on our behalf. My name is Louis Esbin. I'm a certified bankruptcy law specialist. And following up on what John Munsell had to say, I had an opportunity to speak to some members of the public the other day who asked me about the CBLS and the program, and they wanted to know more about what the CBLS did and its functioning and vetting lawyers as we do on a rotating, I think it's 5-year basis. And they found that that was critical, that was a distinction that we did, and I think that's a purpose of the CBLS and the law advisory commissions that is important to the state bar in protecting the public interest. They saw that as an ongoing ability of the state bar to protect the public interest and beyond the CLE that's required, because there's actually a vetting process that we go through that no other area of the bar goes through. And so we had members of the public who I had a chance to speak with who were not lawyers. They were people who use legal services, who refer legal services, and they wanted to know more about the specialist program and how they can have access to the specialist program. And so I'm kind of supporting what John Munsell had to say and others have to say, the importance of this, of the CBLS as a regulatory function of the state law.
All right.
Thank you.
So let me, this is Glenn again, let me I guess, close with one.
Could I just make one more comment?
Okay.
Before you close? Sorry. Richard Michael Berg. I understand where you're coming from in terms of the regulation and discipline as opposed to the member benefit aspect of it. And certainly we're all keenly aware of that. But a little bit on the flip side is I don't think you can just completely discount that there should be some benefit to the lawyers that put the time in and go through this in terms of marketing. I know it shouldn't be number one, but I think there is a little bit of value to that in the sense that everybody that went to law school obviously didn't go in for just public benefit. You have to make some money, thousands of bills to rack up, student loans to pay back. So I think there is a, how would I best put it, a balancing that could be done in terms of public safety and marketing for lawyers. I know that that's obviously number one, is safety. How can I best put this?
No, I think I understand your point, and actually Natalie and I had a good discussion on this exact point, because what she was saying is, look, just because some people construe this a certain way, or because, unfortunately, in an older ABA publication, they say, hey, this is going to really increase revenues for you bar associations, they'll allow it, it's going to increase your revenues. Just because somebody says that does not mean there's not another higher purpose that California adheres to. So there's nothing wrong with ABA trying to promote it that way in a sense, but that shouldn't obscure the other purpose, which is an appropriate purpose. So I think I understand what you're saying.
I couldn't have said that better. The other aspect of it is I know it's been compared many times to the medical profession, and I think that even you would probably agree that if you were going to get diagnosed, or if you were diagnosed and needed to get surgery, you would probably feel much more comfortable getting a medical doctor that had been certified in the area of the disease that you were going to be operated on, as opposed to just finding any medical personnel, right?
Oh, yeah.
So I think everybody agrees that it's clearly a function that needs to remain. And I think John said it best when he said the state bar with the oversight is probably in the best position to do that.
All right, so I want to, it's Glenn again, I'm going to close this. I want to first thank you for your time and all your effort. And I have a final comment. I'm interested in your reaction, if you have one off the top of your head. As I understand this process as it's been explained, you're doing multiple things, but two things. One of them is analyzing how the CBLS currently functions and is it fulfilling the public protection role and various other things. And then also analyzing if the bar, or we started from scratch, is there a better way to set this up? And the one thing I would say about this, if you started from scratch, it is possible that it might be better, or it's possible that in implementing what looked better on paper, it might turn out that it's not better. And there's a big risk in changing a model if your conclusion on the first question is that it's working really well. And I think that should be certainly factored in. So even if in the abstract you might be able to bring us from a 90 to a 95 if you started from scratch, if you do conclude that we are serving our function, doing it well, doing it financially well, and serving the public protection, is it worth the risk that in the abstract it would be better, might turn out not better? So I just wanted to say that. I don't know if you have a reaction, or if not, again, we thank you for your time.
Yeah, no, and I think that you're right. I mean, that is certainly part of the calculus, is figuring out, some of these, again, I think there are some in CBLS, is not one of them in my view, but where should the bar be doing this at all? That's a reasonable question to ask. When you look around the country and see bars doing things outside of themselves that are important and related, but just not an appropriate function for the bar, and I think part of that question is: are we, given that it's important that it be done up to professional standards, and that's part of the question: is are we meeting those standards when we talk about functions like accrediting law schools or grant making or other things? And again, so I think that question gets posed in different contexts in different ways. But no, certainly the risk, the cost benefit analysis of this from a organizational perspective has to include that, exactly what you're talking about. If what we really need in one instance is improvement, then let's improve it. Let's not throw the baby out with the bathwater, as the old saying goes. So, no, I suspect that, and just to be clear, what I'm doing is, as you said, is trying to make sure that I am accurately describing the work of each sub-entity, and then accurately framing or even reframing questions in a I hope more informed way, based on what I'm learning from you, what I've learned from Natalie and others, so that they can be asked and answered in the most meaningful way. And I don't know what the board's going to do exactly. I think I can imagine a scenario where they think the path forward is maybe clear with one sub-entity, with another one they want additional information, or they want additional opportunities to solicit information from other stakeholders. And I can imagine a variety of ways that the board could decide it wants to keep going on some of these and really make the right decision. I mean, I don't think they're eager to just kind of wield an axe and then hope for the best. That would be grossly irresponsible, and nobody's interested in being that way. So I think it'll be a thoughtful process and hopefully better one for all the information that I and you have been providing them. So again, I would encourage any further comments to come through Natalie. We will circulate the draft of this descriptive piece and just make sure that, and the concerns as part of that, and make sure that an accurate reflection of the current state of things so that the board can make the best decision going forward.
Great, and I know you had said your final report is due at the end of August. Do you have an estimate of what the interim report or draft you're going to submit to Natalie when we might get that?
Oh, I mean, as soon as she and I can clear up a couple of just minor factual questions, I think we can send this out quickly. I will try. I can also try to write up our discussion today as part of this and include that, because that would be. I want to make sure I'm reflecting what's been said today accurate as well. So I would be able to get that out. Well, I'll be bold and say by the middle of next week, if we can get together timely. The Board of Trustees is meeting, and other set of conversations I have to prepare for that. But yeah, in short order.
Oh, that's great, and yeah, thank you again. I know you're super busy today, and we look forward to meeting you in person at one of our future meetings. But have a good rest of the afternoon.
Well, thank you, and I appreciate the thoughtful comments that people made today, and look forward to continuing the conversation.
All right, and we are going to go off the record and take our lunch break so we can turn off the cameras. And thank you again, Richard. And,
all right, thank you.
All right, well, we are back from break. Thank you, everybody. We are moving to page 219 of the agenda, the AIMS status update, and as everyone knows, that stands for Admissions Information Management System. Natalie, I believe that will be you giving the update.
I'm happy to do that. And Adrian, please chime in anywhere you would like to with respect to this update as well. So AIMS is the Admissions Information Management System. It is the system that's going to replace our AS400 mid-range mainframe system that was created in the late 80s and early 90s. It has a Salesforce platform as its backbone, and we've hired a Salesforce integrator to help us customize Salesforce to what we'll need at the State Bar for all of the admissions functions, including the specialization. So this integrator, their name is Slalom. Their process is discover, deliver, and transition. So discover, we gave them specs. We went through a public contracting process, and they were selected as a vendor. Others were also considered. And during the discovery period, they said, well, okay, you told us generally you wanted this, but let's meet with each of the departments and find out specifically what this means. So that was a process that we've been going through for the last several months. That is now closed, and now they're in the deliver phase, where the various pieces are divided into sprints. And during a sprint, they say, hey, we're going to accomplish this much, and we'll show you as we're going. And they have a software system called Jira that kind of manages that. Once the product is actually delivered, we get to stress test it against criteria that were set at the beginning, and then they'll teach us how to take care of it once they finish. They'll be a continued company. We can still get advice from them. We would hire them if we wanted to do that then. So Adrian has also been integral in this process as well. And we'll be looping in Cynthia for her expertise as a public member. And I think that's going to be very valuable in making this a very useful product that is really making better use of staff time, but also better presentation to the public and to the specialists, and able to offer that online payment and application experience that I really think people really expect these days. I don't know if Adrian and or Cynthia would have anything that they like to add.
Adrian? You have nothing?
I mean, I guess discovery was, I mean, it wasn't just me, it was the whole team, Crystal as well. It was a long process, and now that we're going to build, it's good to see where all that work is going to be headed, and get to see the different steps, and we'll be able to make adjustments as we go along. It's not just one build and then they're going to let us go. So.
Cynthia?
So I didn't attend the meeting this past week, but I'll attend going forward. But I did get a chance to talk to several that attended the initial sprint review. And I like the direction that I've heard, and I've given feedback to the team. And so I've also worked with Solomon in the past on different projects. And so overall, I'm very positive in regards to the direction they're making. And as Adrian and I were talking earlier, it'll just get better and better as the meetings between sprint planning and sprint reviews go on. And we can iterate to really make a better product that's useful now, as well as giving future potential changes. So as to begin to address some of the issues that we heard earlier, we can build that into the product. And so the whole method that Solomon's using will help us to be more nimble and futuristic, providing the solution that we need. So I'm very confident with the progress the team's made.
Great. Well, thank you for all of your efforts. And does anyone have any questions or comments? Lou?
My only question is, this is a program, a product, a system that being implemented by CBLS. That's correct?
Jointly with all of the admissions, so it will be an integrated system
That was
for all of the admissions.
So we're doing this as part of the larger bar admissions, so that's an integrated system.
Yes, and it will also pull the information that we need from Attorney Regulation and Consumer Resources, the former membership services, as well. And attached to your materials, you can also see a short PowerPoint that we weren't planning to go through today, but in case you just wanted to see the methodology of what we've been using. I know this is something that many of you have wanted for a long time. We're very glad that it's here, and I do feel like this vendor was head and shoulders above the others in terms of the time they were willing to invest, what they offered, and the wonderful rave reviews that they got from other customers. So I'm hoping that we and you will have a similar experience with this company.
Other comments, questions?
Oh, I have a question. On
Yes.
page 233, there's this triangle of desirability, viability, and feasibility. Is this the crux of how decisions are made regarding what is needed in your new system?
Yes. Yeah, so these are things that we trade off at each point. So there are certain things that you have to have, and then there are certain things that you want to have more than time or funding would allow. And so for those items in sales, that's the calculus used to help decide. And also there may be at the end additional ideas for the future in a backlog that could be addressed in a future phase. But we believe that when this finishes, everything we need to replicate what we do now in a modern way should be it.
Thank you.
Danny, how will the public see this? What is it about the system that benefits the public, other than not necessarily the bar and the member and the staff of the bar, but how will the public perceive this? How would it benefit them?
Well, because it's still developing, it's hard to say for sure. The public will still primarily receive their information through the website, which may be fed by the Salesforce system rather than going into the Salesforce system directly. But I think the public is served through the staff efficiencies that will be achieved, the ease of access for people who can apply, and freeing up that time will actually make available more initiatives that have been in your backlog, reaching out to consumers in other languages or other things that have been on the list where there hasn't been the time. That time can be redirected, time spent in application processing or data entry or credit card processing can be redirected to these higher value public protection tasks.
So going back to the presentation we had earlier where there was a discussion about efficiency, this greatly increases the efficiency of our programs.
We believe so because we believe there will no longer be very much manual data entry, manual opening of mail, manual collection of INRs. They will become electronic by computer at first and possibly eventually via phone.
So ideally, what we could do is that we could provide these type of metrics and data analytics to the earlier presentation in regards to how the system will make resources in VAR and CPLS much more efficient through this new product.
Absolutely.
Anything else? Do we have a motion to receive and file the report?
Awesome.
Second? All in favor?
Aye.
Opposed? All right. Thank you. Moving on to page 238 of the agenda, educational provider rule adjustment proposal. Natalie.
Sure. I'm sorry, you're probably going weird of me today. Many of the proposals are coming from me. But this is a staff proposal related to another IT initiative at the State Bar. I placed this after AIMS on the agenda to help differentiate between them. AIMS may be fed by other systems, even in a future state. And one of those is one that's yet to be created that will affect all of the attorneys in this room, but also statewide. The State Bar is undertaking the creation of a system that will allow providers, including legal specialist education providers, to log all of their courses and all of their attendees with the State Bar. And that will also mean that you as attorneys will have a large portion of the courses already recorded by the provider when you're keeping track of them, which it's hopefully a big convenience. Compared to other states, most other states do some sort of census reporting like that, rather than the every 3 years reporting that we do here in California. And so it's hoped that it will give the bar more oversight, more control, and it will give attorneys an easier way to keep track of their education. Perhaps also the state bar can be helpful, reminding you, hey, your deadline is coming up. If you haven't completed these or those special subjects, or you have done so. The timeline is still being worked out for that, but it is probably within the next 12 months. But as part of getting ready for that, there is a cleanup change that is proposed for you. And we'll get to that in a minute. But first, does anyone have any questions about this provider system?
Just a question about, what if you're teaching, or how will they keep track of your CLE, that teaching?
There will still be manual entry elements, and my guess is that will be an example of one of them. Or perhaps you take a CLE while you're in Maine or something like that. You'll still be doing those things. We also expect that for legal specialist education, in some cases you have an equivalent that you can choose, such as an MCLE equivalent, and you will probably mark that individually if it's not a pre-approved course.
Makes sense.
Then does this envision that at some point attorneys will be able to log into the state bar profile, state bar account, and look and see what MCLE has been reported?
Yes.
Does this tie into Ames at some point?
Yes, and exactly how is still being worked out because both Ames and this system are being spec'd out. So we're watching both and trying to think about how it is that they should talk to each other.
So was that your report, or do you have a second?
So that's the background. As part of getting ready for that, when this board moved from reporting the education every 5 years to reporting every 3 years to match with MCLE, since that time, for about 5 years, you've been waiving the subfield education requirements in specialization. Not the mandatory MCLE subfields, which this board would not have the authority to waive, but the subfields within individual specialties for a couple of reasons. One, just being a logistical reason, with a shorter time period, would be difficult to have many different small categories of education in each instance, or have those be exactly what an attorney needs. But also, number two, rules were created long ago when there was no bar-wide minimum continuing legal education. So you needed to set out some real estate and say, hey, the state bar is trying to encourage some courses, let's start with these. Well, now, in many of the established subjects, there's a much wider range of courses. So to keep these specific areas might actually limit what an attorney can take in this one small way. So you've been waiving those for the last 5 years. It would be appropriate to consider a rules change which would waive them permanently. So as we are developing the new system, it would reflect the actual practice and a more modern balance of freedom and control for the attorney.
Okay.
And so there is a proposed staff memorandum that would do exactly that, and it would waive them in exactly the way that you have been doing for the last 5 years. The overall educational requirement at 36 hours for 3 years would stay the same, and the attorney would now have the ability to choose within the subfields.
And then it looks like there's a Part B and Attachment B where each individual, if I understand it right, each individual advisory commission made modifications to their rules that we're supposed to vote on and approve or not approve.
Right, so to the extent that this may also change the applications, we're bringing that to your attention. You would want to correctly describe in the application.
Okay. Questions, John?
Question. So, Glenn, if I understand your question, each of the changes that are on these specific standards have already been vetted and recommended by the respective commissions. Is that
Yes,
correct?
that's correct.
I have a question about the one in family law.
What page?
More out of curiosity.
Just point us to the page.
Oh, sorry, page 254. Thank you. Section 3.0, first paragraph. It's creating a new exception. Instead of 45 hours of educational activities specifically approved for family law, it says, or has received within the 5 years immediately preceding the application an LLM degree in family law from a law school accredited by the American Bar Association, attorney the equivalent of the advisory commission. Showing my ignorance, I never heard of an LLM in family law.
It's really just being consistent, should those be developed, the rules are changed infrequently, and that's how LLMs are considered in the various other groups where they may be common, such as tax. So it's really just laying the groundwork in case that should be something developed in the future, being consistent.
So is that in all the rules?
And you'll see it frequently in some, like maybe sometimes a state would certainly tax, but in others, admiralty is another one, where maybe people will choose an LLM, but some really don't see that very frequently.
I anticipate there's going to be some appellate folks that are at least concerned about these changes and how they're going to apply for people that are in the middle of there. Because appeals was one of the few that actually, the appellate specialization allowed you to essentially do half of them in substantive law topics that were not like appellate specific. And like now the 36 hours have to be approved for appellate law. So I can see like a fair number of people going, hey, by the way, I planned my education such that only like, you know, I mean, like if it's, it just, I think it's just something to like a tickler just for people that might be in the middle of their compliance period.
That's a good point. So that might be needed to be spelled out in the transition. Okay.
Lou?
Yeah, I guess they're all the same. It says, I'm looking at bankruptcy, right? It says specifically approved for bankruptcy law. Who approves?
It's the same procedure as it's always been. Staff according to the guidelines, putting exceptions to the advisory commission and CBLS. So no change. No change is contemplated from what you've always done for forever.
Any other questions or comments?
So I have a question again on appellate law. Because that language was added at the end of 36 hours, is that the big problem?
Well, because theoretically, like before it was 25 of the required hours must be in appeals and writs. So like that was a 5-year one, so that essentially I think most practitioners just took the 3-1 to be, well, I need to have at least 15 hours in, you know, the appellate specialization credits, and the other ones can be in substantive law topics. Like now, we're going to go from 15 hours have to be in substantive law topic, 15 hours have to be in appeals and writs to all 36 have to be approved.
Okay, but here's, Roy, here's my question to you then. Language was added after the 36 hours specifically to say
approved for appellate law, yeah.
So if that language, if the first part of it, which was not added, approved 36 hours.
Of approved educational activities. So it was.
If the language added was stricken, would that satisfy your problem?
No, well, because the problem is if we did it, then it would just be 36 hours of approved educational activities, so it could be any MCL. It would have to be. I think it's fine as it is. It's just people that are in the middle of their compliance period are going to be like, hey, wait a minute, I may have planned my education in a different way.
I have a question about that. Do you think it's something we should bring back to the commission for clarification to be certain that they understood? Because in appellate, so much like you would see in legal malpractice, it is important for the practitioner to do skills and underlying practice education.
Right.
And there are fewer courses specifically on the mechanics of an actual appeal, and as time goes on, they may be less necessary. So might it be appropriate just to reconfirm?
I think so. I mean, like, look, I'm just speaking for my own experience. Like, appellate specialization hours are kind of tough to come by. Like, there's just not that many. A lot of like local bar associations do like a monthly thing where like you can get an hour here, an hour there, which is if you plan in advance enough and you do a few courses online, stuff like that, you can do it.
Isn't it solved if the approved educational activities included appeals and writs and pretrial, trial, or post-trial practice, then you're in the same, you have the same issue as you had before and you're fine, right? Like you're reading this to say now you need 30 or 45 hours of just appellate appeals and writs, but
You need 36 hours. 36 hours of only appellate specialization credit. If you did that, if you did yours, then theoretically they could get away with doing no appellate specialization stuff because it would include everything. I think essentially if it was left 36 hours of approved educational activities, not less than 18 hours of which were to be appeals and writs, and the rest can be in the other things, then that would probably be fine. And frankly, that could just be like a way station. That could just be a waste. I have no problem with setting it as 30. Look, you have to do 36 hours of appellate specialization. That's fine. It's just I could see people that are in the middle of their compliance period going, hey, wait a minute, like we're going to comply with X, now we have to comply with Y. In all the others, it seems that it's becoming less restrictive. People can like go to more things. Here, it's actually putting on another like an additional requirement as opposed to taking away the requirement.
Roy, let me ask you another question. In your personal view, how many hours in a 3-year period should a person in appellate law, certified in appellate law, have to take in appellate law to remain certified?
Honestly, the way it was seemed like a pretty good sweet spot, which is that half the stuff can be essentially in generalized substantive MCLE, and the other half has to be specifically appellate stuff, like current cases, that sort of thing, like tidbits from the Court of Appeal and some of these things. That seemed to be a pretty decent sweet spot for appellate. Or that all 36 hours being from appellate seems frankly a bit of overkill.
So mathematically, I'll ask you a leading question. Is 18 hours the sweet spot if 36 hours is the total?
I think 18 is a good number. I mean, if it was 20, I don't think anybody would rebel.
Based
like
upon what you're saying,
but 18 being half, I think that makes sense.
Right, and based upon what you're saying, I think Natalie's suggestion of sending it back to the advisory commission makes a lot of sense instead of us jumping on the boat and over.
Oh yeah, I wouldn't want to big league this thing. I wouldn't want to
big league
this thing.
On everything but appellate, or just hold off on everything until after we get clarification on appellate?
You can either seek clarification, or if you feel comfortable with a modification, we can look into it and perhaps keep in touch with the executive committee plus Aurelio if we run into an administrative roadblock.
So vote on what we're going to vote on now, and then do everything you said later.
I can suggest something and then send it back to them.
So you can send it back, you can modify it, or you can adopt it as proposed.
What do you recommend?
I think it depends on, I do see Aurelio's point. I think he correctly describes the situation for appellate attorneys and what they need to keep their practice current. And this may have been an oversight when they were considering it. Perhaps they do need to be a little bit different. You may feel comfortable enough. I could really see it going either way, or you may prefer to just get some confirmatory feedback from the advisory commission.
Okay. So we can vote on everything but appellate? This is one of the options.
Well, wait. I have something about work comp.
Well, let's deal with appellate. Let's finish that, but then we'll go to you. Okay. So if we wanted to, could we modify it to vote on the rule changes for everything but appellate, or do you prefer to do it all at once?
I think if you feel confident, there would be an advantage to doing it at once, because I think it was contemplated that this would go to the board in September. So that would leave you time to have a smaller group consider any feedback received by the advisory commission, but maintain the board of trustees schedule.
Is the board of trustees meeting before or after our next meeting?
Before.
And then we would vote again if there were changes?
If it's within what you discussed today, you could delegate the authority to proceed,
Okay.
and that would work.
Bob, you had a comment on workers'
Right,
comp?
on the workers' comp, I mean, it's pretty much the same, but as you know, Natalie knows, we may in a year have 20, 30 cases set for trial, and sometimes you don't go to trial at all, you settle them. for example, one of my partners has never tried a case. She settles every case.
I think, I'm gonna hold you right there because of what we were asked by the board at this point to look at was specifically the area of education. And so going forward, there may be the opportunity to look at the standards, but right now we're really kind of tightly focused on the level of education. Okay. And that could be considered in the future, absolutely.
Sure.
Yeah, I guess I had a similar question on family law that has nothing to do with education. I know.
And I think also that would be something that we would take up.
Yeah, somebody had talked about tinkering with the experience requirements, and I was just curious.
That would be in line behind this, because this is a project with a timeline attached to it. And
Okay.
so I think the requirements would be something that would be considered post-appendix I, post aims, and provider implementation, because that will occupy the department for the balance of the rest of this year for sure, and possibly beyond, but certainly the balance of this year. So there are some various that are considered across the specialties, and that's something that would be
All right, so keep me honest if I get this wrong, but I think the slightly modified resolution would be that the CBLS approve waiving the subfield requirements for all specialties for education, adopting the attachment B revised certification standards subject to Aurelio looking into whether there needs to be a slight modification on appellate per what we discussed today.
And so I'm happy to broker that communication and invite anyone interested to join or listen in at the Appellate Advisory Commission or otherwise to report back.
Can I go on Hummingbird and have like suggested language that they can chew on as much as they want?
And if Aurelio comes back with language that is consistent with our discussion, that appellate education could be broken into appeals and writs plus some hours of trial, pre-trial, then we're voting to approve it now, so we don't have to vote again. Is that how?
Yeah, so I might suggest that they be adopted in principle, but be open to a modification to replicate the split between appeals and substantive skill courses in appellate law.
Okay, so with what Natalie just said, if everyone understands what we're moving on, do I have a motion?
So moved.
Second.
Second? All in favor?
Aye.
Opposed?
And to be clear, I will make note of the task and experience items that were brought up, but that were not noticed for discussion today as a topic for future meeting.
So that's the end of the open agenda. I guess, is there a motion and a second to end the open portion of the meeting?
I move.
Second?
Second.
All in favor?
Aye.
All right, well, we are done with open session, so thank you. We'll break for a minute while the camera turns on.
Look at that.